Hello guys and welcome to the Lawputra's YouTube channel. Today we will discuss about the case, very famous case, that is Vishaka and others versus state of Rajasthan and others. A typical very landmark case in the sexual harassment issue prevailing in India. I am Jagannath Kulkarni and today we are discussing the case which is reported in the All India Reporter year 1997, and it is decided by the Supreme Court of India on paragraph 3011. This is the citation of the case Vishaka and others versus state of Rajasthan and others. This is a writ petition. This case was a writ petition. It is filed for the enforcement of fundamental rights of working women under Article 14, that is equality before law, Article 19, that is protection of certain rights regarding freedom of speech, etc., also of the profession, and Article 21, which talks about the protection of life and personal liberty. While we say protection of life, life means life with dignity. And these articles, these are enshrined under Constitution of India. In view of the prevailing climate, the then prevailing climate, in which violation of these rights is not uncommon, even today we can observe this. And with increasing awareness and emphasis on gender justice, very typical, increase in effort to guard such violations, and therefore resentment towards incidents of the sexual harassment is also increasing. Even now, today also we can find this. And this case is a class action by certain social activists, public spirited citizens, and non-governmental organizations. And their aim was focusing attention towards this social aberration and, most importantly, assisting in finding suitable methods for realization of true concept of gender equality. All are fighting for this. And finally, to prevent sexual harassment of working women in all workplaces through some judicial process, and to fill the vacuum in the existing legislation. Whatever legislation is prevailing that time, we need to fill that vacuum. And for this case, what was the trigger? We have to go back to the year 1985, where Bhauri Devi, who is called as Sathin, which means friend, she was a social worker at Bhateri village in Rajasthan. She was working under Women's Development Project, which was run by Government of Rajasthan. In 1987, she took up an issue of attempted rape of a woman of some neighboring village, and in this incident she gained full support from the members of village. After 5 years, in 1992, she took up another issue which was part of her job, and this was the government's campaign against illegal child marriage. Though the members of the village were knowing that this was the illegal, they given their disapproval and totally ignorance. And in 1992, in the same year, one of the villagers, Ram Karan Gujjar's infant daughter's marriage he planned for. Bhavri Devi tried to persuade him not to perform that marriage, but her efforts were futile. What happened on 5th May of 1992, SDO and DSP of that village came, the jurisdiction person came, and they stopped this marriage. But it was performed on the next day. Instead of 5th, it was performed on 6th. Police took no action. But what happened? All the villagers, they boycotted Bhauri Devi and her family. Bhauri Devi lost the job also. After few months, 4 months, 22nd September 1992, the villagers and especially this Ramkaran Gurjar wanted to take vigilance. And Ramkaran Gujjar, Ramsukh Gujjar, Gyarsa Gujjar and another person, Shravan Sharma, they attacked Bhauri Devi's husband and brutally gang raped Bhauri Devi. Obviously, what happens in case of common person, same thing happened here also. Police tried all possible ways to avoid filing any complaint against accused. They delayed the investigation. Even Bhavri Devi's medical examination was delayed for 52 hours. Examiner did not mention any commission of rape. Instead, he mentioned the age of victim. So what happened? Absence of sufficient evidence. Again, the help of local MLA Dhanraj Meena, and all accused managed to get acquitted through in the trial court. Huge backlash from many women activist organizations supporting Bhavri Devi. And these organizations came together, raised their voice for justice, and filed this PIL, public interest litigation. And this is the famous case Vishaka and others. Vishaka is the name of NGO and versus state of Rajasthan and others. What issues were raised? Number one, whether sexual harassment at workplace amounts to violation of rights of gender inequality and right to life and liberty. Second issue, whether court could apply international laws when the domestic laws are not available, and whether the employer has any responsibility to prevent this sexual harassment if it is done to or by its employees. Petitioner argued that indecent acts of sexual harassment of women at workplace violate fundamental rights which have been enshrined under Constitution. And Article 14, equality before law, Article 15, that is prohibition of discrimination on grounds of religion, race, caste, sex or place of birth or any of them. Again, subclause G, most important of clause 1 of Article 19, which talks about the protection of certain rights regarding freedom of speech, etc. And particularly this subclause talks about to practice any profession or to carry on any occupation, trade or business. And ultimately Article 21, which talks about the protection of life and personal liberty. So these rights gets violated with the sexual harassment. And there is legislation's loophole also regarding provision of safe working environment for women, and that's why the petitioner requested the court to frame guidelines when there is no existing law, to frame guidelines for preventing sexual harassment at workplace. What happened for the respondent? Learned Solicitor General, who with the consent of the respondent appeared for the case, he did something unusual. What happened? He supported the petitioners and assisted the court in figuring out effective method to curb sexual harassment and in structuring the guidelines for its prevention. And friends of the court, which is popularly called as amicus curiae, Falias Nariman, Miss Naina Kapoor and Miss Meenakshi. And the judgment came. Lack of domestic law to prevent sexual harassment, to provide women with a safe working environment. There was no law. IPC section 354, which talks about assault or criminal force to woman with intent to outrage her modesty, and section 354A, which for sexual harassment and punishment for sexual harassment. But these two sections were not specific for issue at hand. And there is need for proper and effective legislation to deal with sexual harassment. Also, reference from international conventions. The first one is Beijing Statement of Principles on Independence of Judiciary in Law Asia region, to function as guardian of citizens' rights and independently make laws in absence of any legislative framework. First international convention. Another was Convention on Elimination of All Forms of Discrimination Against Women. And this convention talks about two things. One is subclause A and subclause F of clause 1 of Article 11, which says state take all appropriate measures to eliminate discrimination against women in field of employment. And another Article 24, which says state undertake to adopt all necessary measures at all levels aimed at achieving its full realization. And ultimately, Supreme Court framed the guidelines, which are popularly known as Vishaka guidelines, to prevent sexual harassment at workplace, and these guidelines are to be treated as law under Article 141 of Constitution, which talks about law declared by Supreme Court to be binding on all courts of Indian Constitution. These guidelines were foundation for the act which was enacted in 2013. Just bear in mind, it took almost 16 to 17 years to pass the act, and the act is the Sexual Harassment of Women at Workplace Prevention Prohibition and Redressal Act 2013. Let us see what were the guidelines, Vishaka guidelines. Number one is employer or other answerable person is bound to preclude such incidents from happening. If happens, then there must be some mechanism to provide conciliatory prosecutionary facilities. Second is what is sexual harassment. It is disagreeable, sexually determined behavior, direct or indirect. It can be physical contact and advances. It can be a demand or request for sexual favor. It can be sexually colored remarks. It can be showing pornography, or it can be any other unwelcome physical, verbal, non-verbal conduct of sexual nature. Then every employer is under obligation to expressly notify prohibition of sexual harassment. Rules or regulations of government, public sector bodies must include rules and regulations for prohibiting sexual harassment. Again, standing orders as per the Industrial Employment Standing Orders Act 1946 should include such provisions. Again, working conditions must be appropriate, unhostile for women employees of organization. Female employees should feel a sense of equality in atmosphere, working atmosphere. When offences committed are of IPC or any other law, Indian Penal Code, then the employer is bound to start prosecution by complaining to appropriate authority. Employer must provide the victim all sort of protection while dealing with complaints. Again, appropriate disciplinary action shall be taken for violation of service rules. Again, irrespective of fact, particular act constitutes offence under Indian Penal Code or any other law. Organization must have mechanism to deal with it. Then, complaint committee must be headed by women. At least 50% members should be women. It should include NGOs or other committees members. Then committee must be adequate in providing relief to victim with appropriate counseling facilities. Annual report needs to be submitted, and then employer-employee meeting shall be arranged, and employer shall take adequate steps to spread awareness to curb this social evil. Mahatma Gandhi once said, he said, the day on which a woman can walk freely on the roads at night, the day a woman can walk freely on the roads at night, that day we can say that India has achieved independence. Thank you. Thank you very much. Today we discussed the case Vishaka and others versus state of Rajasthan and others, the landmark case in India for curbing the sexual harassment at workplace for working women. Thank you.